Thank you all for joining us today for our ASCA webinar, ASCA Legislative Update, the Campus Accountability and Safety Act and other proposed legislation. We're very excited to have almost 500 sites signed up today attending with us, and very excited to welcome our non-members, and hope that you will enjoy this session and consider joining ASCA for more events like this. Today we have some great speakers joining us. We have our current ASCA president, Matt Gregory, our incoming future ASCA president-elect, Laura Bennett, and our immediate past president, Chris Lashivo, joining us, along with Sean Callagher, who is the chair of the ASCA Legislative Issues Community of Practice. These experts are going to share some wonderful information today. I hope that you will take the opportunity to ask questions and get information from this that will help impact your practice on your campus. And we'll go ahead and get started right now. Thank you, and enjoy.
Thanks, Sarah. This is Sean Callagher. I'm just going to give everybody a quick outline for today's webinar. First, we're going to go over the proposed legislation. There are 3 federal bills that we'll be focusing on. Primarily up front will be the CASA bill, talking about what the major provisions are within the bill, as well as what the impacts and questions we have as student conduct administrators. At the end of the presentation and the webinar, we will talk about what are the themes we're seeing, not only in the federal legislation, but things that we are seeing coming up in various state legislatures around the country. We'll talk about the legislative process and how these bills make their way through Congress, and looking at what the possible outcomes could be in the near future and looking into next year. And also we'll be discussing what ASCA is doing on this front and our advocacy efforts that cover a lot of different topic areas within this broader topic of campus sexual assault and how the government's now becoming more involved in that. And hopefully at the end we'll have some time to answer questions that you can submit through the webinar software. Quickly, we'll just briefly go over what are the 3 federal bills we'll be discussing. The Campus Accountability and Safety Act will be the first thing we'll be discussing. And there's actually 2 bills that were proposed concurrently in the House and Senate that are the same bill, but they're being brought forth in both houses right now. After that, we'll discuss the Survivor Outreach and Support Campus Act, which is shortened to SOS. That also has a supporter in both the House and Senate that have proposed on both sides. And then lastly, we'll discuss the Hold Accountable and Lend Transparency Act, also known as HALT, which has been proposed in the House. So let's you can start a discussion with CASA, and I will turn it over to Matt Gregory.
Thank you, Sean. I want to take a moment and thank Brian Glick for all he did to be able to help us in terms of putting this webinar together. His name was mentioned on a couple slides ago, but I wanted to say that again. I also want to clarify, Sarah referred to me as an expert, and I want to clarify that I actually stayed at a Holiday Inn Express last night, so I'm just feeling maybe a little bit overconfident. The first slide we're going to talk about, or that we have up in front of you, is the list of current co-sponsors. And I think something that is important to note here when you look through the list of folks who have currently signed on, in terms of senators and also members of the House, is there is a requirement that when a senator or congressman signs on, that they do so with a opposing party member to show the support and solidarity. So if a Republican signs on support of either a bill, there is an expectation that they would try to find a Democratic sponsor who would also be willing to sign on with them. So it is an interesting approach that you are looking at in front of you. To dive right into it, what you see in front of you is an overview of some of the major points of the CASA bill, the Campus Accountability and Safety Act. A few of these 10 that I would point out specifically, and we will spend some time in the next few slides, myself and Chris, talking a little bit more about CASA, is the national survey that is mentioned, and also I think what may be a source of confusion on confidential advisor. There is some guidance and recommendations in terms of establishing an MOU with campus law enforcement agencies. I think also of interest, and I believe many institutions may already have this in place, is an amnesty policy. And then lastly, the enforcement provisions that might be enacted should the bill pass. The first part that I'll spend some time talking about speaks to the survey that is mentioned. And I think a potential or a particular note that is the survey itself is actually something that would come from the Secretary of Education and the persons within the Department of Education. It's not necessarily an expectation that universities create this survey, that it would be potentially something that would be created by the federal government. Here are some points of that survey. Now, if by chance, though, a university did decide to try to create their own survey for the purposes of conducting perhaps a climate survey on your campus, these elements might certainly be worth consideration should you find this of value to your institution. The reporting numbers that were specifically mentioned as an interest was the number of sexual assault cases by institution, number, and this is all statistical if you look at these items, disciplinary action, number of cases referred to local or state law enforcement. That would absolutely call for some type of arrangement with your local law enforcement community to ensure that those statistics are being reported back, to be able to ensure accurate numbers. Also, the number of persons who were found responsible or not responsible. The description of any sanctions that were levied to a student as a result of a sexual misconduct hearing and in the situation where that student might have been found responsible. So that could be a description coming from your code of conduct that details what that sanction might actually mean. In the event that the code of conduct does not specifically detail it, you would have to be able to articulate what that sanction might be. And then lastly, the number of cases that occurred on these topics in terms of sexual misconduct cases that did not result in a formal resolution but were indeed closed by the institution. And I mentioned the survey coming out from the Secretary of Education, or that would the Secretary of Education would have to be responsible for, and you see that slide in front of you. The second point talks a little bit about the anonymous nature of it, and you could also use the term confidential, but the idea, the takeaway is that by completing the survey, that would be difficult to be able to reach back to a specific individual just from the answers of the survey alone. So that, it is intended to be private and protect the identity of the persons who are creating the survey. But the terms anonymous and confidential, certainly is intended to protect that person. There is mention in the bill language that talks about this survey in light of climate and maybe a tool to be able to assist institutions in getting to the point where they might satisfy a requirement of having a climate survey to be able to check on that particular institution's environment in light of sexual misconduct on campus. Another takeaway that I think is appropriate to point out is in the proposed language of the bill from CASA that there is conversation about while the Secretary of Education and the Department of Ed might be responsible for developing the survey, the institutions potentially would have responsibility to ensure an appropriate sample size. And it also goes on to mention that failure to complete that requirement and not have a appropriate sample size or failure to do the survey completely would result in potentially a fine up to $150,000. In the conversation in the bill looking at the national survey, another point that is raised is a need to clarify the difference between a responsible employee and a campus security authority, that indeed those two, in terms of the proposed bill language, should be fairly equal and aligned. And that may not necessarily be the case on your campus at the moment. But there is a mention in the bill language about having those two positions that are mentioned to start to align. The next slide that you're looking at, that you have in front of you, speaks to the confidential advisor. And just as I was mentioning some confusion perhaps between responsible employee and confusion with the Campus Security Authority, I think there's a potential for some confusion on the front of a confidential advisor versus an advisor of choice, which has been some other language that we might have seen, and perhaps even in a responsible employee. So looking at the points here, the idea, I believe, is trying to encourage reporting options, having an array, multiple reporting options available to a student who may be a victim or maybe a survivor of a sexual misconduct act, and having an opportunity to be able to choose potentially the appropriate option for them should they want to report or talk to somebody. And perhaps that is a person who has some confidential privilege, either in their employment or perhaps as a community provider, that can guarantee and ensure confidentiality. And that is trying to give them more reporting options. So that's where I believe confidential advisor is coming from. I don't believe it's intended to muddy the waters in terms of a CSA or responsible employee, or even another, like an advisor of choice that might participate in a campus process. Going along a little bit more on the notion of the confidential advisor, and depending upon your institution and your resources, the reality is if you are at an institution that may not have the type of resources or the type of staffing patterns that would allow for a full-fledged counseling center or a fully trained victims advocate who might be able to claim confidential privilege, there may be a need institutionally to be able to contract with community providers to be able to fulfill the role of providing a person who can and has received training to be able to assist a survivor of a sexual misconduct matter and be able to speak to their experience as potentially a victim, to be able to use language that is trauma-informed and be able to focus that contact with what a person might experience in the aftermath of a sexually violent incident. And I think naturally with the confidential advisor, there would be potential for some overlapping roles. And if the person is truly confidential, where they maintain a position in a college or university that they are employed in the capacity of being a confidential provider, meaning they have a social work degree or a counseling degree, and that is the position that they're employed to be. So different from somebody who might be an academic advisor and their primary role is to advise a student on their academics, but they might also carry with them a licensure in social work or counseling, but that's not their capacity. That's not how they're employed. There could be some potential for overlap, but if the person is indeed employed in a role that carries confidential privilege, meaning they are a counselor, they may be a member of clergy, they may be a victims advocate who is trained to be in that role, then they might not be able to participate in other parts of a sexual misconduct process on your campus, to include the disciplinary process or any investigation because of their confidentiality that they would claim. So there would be some potential for discussions on your campus about the roles of a confidential advisor and what specifically their role might be in the greater context of process on your campus. The bill also talks about, and this really shouldn't be new to us, I believe it was mentioned in the Q&A from the Department of Education, and I think the message from the Department of Ed, and I believe it's clear that from the Senate as well, is they want information on sexual misconduct to be readily accessible, that persons can find and navigate to it fairly easily on your institutional websites, that it provides a wealth of information at the fingertips of the person who might be looking at it. One thought I have on the institutional website, and this largely comes from attending the Garin Academy session, and I remember listening, I had the opportunity to sit in on a part of it, and I remember Sonny Schuster talking about encouraging campuses to maybe not refer to cases as a Title IX case, but refer to them more along the lines of your institutional policy in like sexual misconduct sexual violent behaviors, something that would be institution-specific but might not also be found immediately in state statute, but specifically staying away from calling it a Title IX matter or a Title IX case. And I think the same thing could possibly go for your institutional website. I'm not sure I would create a website and name it the Title IX website. And the reason why I wouldn't do that is part of me wants to think about what terminology our students are going to use to find this information. The likelihood of one of our students to go, I want to go find information on Title IX is actually probably quite rare. Many of them might immediately think of gender equity in sports when they think of Title IX, and maybe not even that. So I do think we have to think of language that we can use to identify these websites that will have all our information from our respective universities in terms of policies, resources available to them, education opportunities that are available and that are regularly used and when those occur, but being careful about the terminology you use and try to use terminology that students will likely use themselves to be able to navigate to such a website. So I mentioned before in the overview of CASA, one key point that will likely be worth some time and energy discussing on your respective campus is this notion of an MOU with local law enforcement. Probably the best example that we have to look at is likely from the joint Department of Education, Department of Justice investigation that occurred with University of Montana in Missoula. If you had the chance to pull the Department of Justice agreement, you will see that there was information that was covered with University of Montana, with the Office of Public Safety at the University of Montana, with the Missoula, Montana City Police Department, and even the DA's office in the greater city and county area or surrounding Missoula. And the notion was trying to identify clear parameters, guidelines that respect the law enforcement requirements in terms of public record and what does not constitute public record, but also the reality that the universities have an obligation to respond. And to some extent, the information has already been collected. So what information can be shared between agencies to allow them to have the information that the campuses can have access to and be successful in their processes, and quite frankly, minimize the chance of re-victimizing somebody by having to ask the same questions over and over again. Naturally, when you talk about MOUs with law enforcement, and when you look at a investigation requirement that the campus may also have in regard to a sexual misconduct case, a law enforcement investigation and a campus investigation are going to likely be very different. There will be certainly some parallels that possibly having an MOU in place and allowing information sharing will assist in. But the reality is, those are not trained law enforcement professionals oftentimes who are doing those investigations. I am aware of some institutions who have chosen to contract with perhaps retired law enforcement in the area to do those investigations as opposed to a university staff member. But I'm aware of many institutions who have chosen to seek training for university staff members to be able to conduct those investigations. Naturally, conduct persons have that as well. So all these entities, the investigators, the conduct person, the law enforcement, will likely need to be parties that are thought about and discussed on your campus in light of what an MOU might look like. And I believe with that, I am going to turn the presentation over to my colleague, Chris, and he will take it from here. Chris.
Thanks, Matt. Before I actually go on to slide 13, I want to kind of reference back a little bit to slide 7, where we kind of talked about reporting requirements and some of the survey, because I think some of those questions about number of disciplinary hearings and number found responsible and all of that are likely to also, if this legislation passes, ultimately end up being part of your annual security report in terms of the numbers you report along with crimes. And I think one of the things that we're still waiting for and will ultimately need some clarification for is how are those going to be explained differently than the crimes, because they're not going to necessarily match up, and I think that's going to cause some confusion. If you just list them out on a chart kind of all together, I think that's going to cause some confusion. And so that's an area that I know we've certainly given feedback and will continue to give feedback on, making sure that we're not creating more confusion by adding more kind of stats to what we're reporting. To continue on with slide 13, talking about anonymous reporting, and wanted to just mention that anonymous reporting has come up in some of the other guidance we've seen over the last several months. But this legislation certainly doesn't require anonymous reporting, but it allows for universities to create online anonymous reporting systems. What I thought was actually interesting about this provision is that it specifically mentions the institution is only obligated to act if a formal report is made to a responsible employee. So, and why I think that's interesting is that is not consistent with some of the guidance we've gotten from OCR in various presentations and things that we've heard, where essentially if the university is on notice and we have an obligation to investigate, and they've talked about even in cases of anonymous reports. Having said that, I think the prudent position will be, depending on what kind of information you have, especially if you get a detailed anonymous report, it's probably still in your university's best interest, especially when you think about safety, to make sure that you are still conducting some level of investigation. But it's going to be interesting to see how ultimately this plays out, because like I said, I think it is not congruent with what we've heard from OCR previously. The other piece about anonymous reporting to just mention here is the idea that requests for accommodations by a confidential advisor will not constitute notice. And so what they're envisioning here is you have a victim advocate, for example, who has to reach out to someone on your campus, maybe in your dean of students office, who can help provide for a classroom accommodation. Well, now, typically when you're doing that notification to provide the accommodation, that dean of students office staff member needs to know who the victim is in order to be able to provide the appropriate accommodation to him or her. And so what this legislation is attempting to say is when that happens, that's not then triggering all of the Title IX investigation requirements simply for following through on providing an accommodation when the report was made to a confidential advisor, which I think actually just it makes sense and is consistent with some of the themes we've been seeing in all that we're hearing from our federal and state government. We will also, as we'll try to answer some of the questions as we go throughout the presentation, but certainly hopefully we'll have time at the end to come back to some more questions. All right, so moving then to slide 14. This is something that actually I hope many of our campuses have already had in place, and this is the provision that talks about amnesty, that essentially when a victim reports an act of sexual violence, Title IX violation, that, and oftentimes in those situations, alcohol is involved, there's, been some underage drinking maybe, for example, that the institution is not going to then turn around and hold the alleged victim responsible for the underage drinking or drug use or whatever it is. And so, and obviously I think that the goal here, again, is about increasing the culture of reporting, creating a more likely scenario where a student will come forward and report an incident. And the belief being that if I think I'm a victim and I think I could be accused or face the conduct system because I was drinking underage, then I may not report the sexual assault. I think that, what's not clear in the legislation is where would that amnesty policy go, but I think the assumption is that it would fit under your Title IX policy and or your student code of conduct. And I know, again, many institutions have something like this in place. This is also very consistent with, in particular, the Survivor Outreach and Support Campus Act, which also has a similar amnesty provision in it. And also matches up with legislation that's appearing in a number of states. So it's not just paying attention to what's happening on the federal level, but we need to pay attention to what's happening on the state level as well. Moving on to our next slide here. Really what this slide is, what we're really talking about here is how do we make sure that students and essentially for enforcement purposes, the Office of Civil Rights know who is it on each campus that can be held accountable. This particular requirement talks about institutions providing name and contact information of the institutional Title IX coordinator to the Department of Education. And this would be a requirement 30 days after the act is enacted, assuming that it does pass. The legislation doesn't require anything further than the institutional Title IX coordinator at this time. The other piece is making sure that as Title IX coordinators change, that the institution has a timeline, essentially, to notify the Department of Education that, hey, we have a new Title IX coordinator, and here's their contact information. In addition, this provision also gives some requirements to the Department of Education in terms of publishing on a national website who each institution's Title IX coordinator is, and different places where students, victims could report any acts of sexual violence. The same website will be where the Department of Education posts investigations, findings, resolutions, and any agreements from the said investigations. And they'll also indicate differentiation between whether the investigation was initiated for a compliance review or because it was covered or created because of an actual complaint being filed. Next provision of the Act talks about who are responsible employees, essentially those who have the ability to redress sexual harassment who are required to report to Title IX coordinator or other university official. It also makes the comparison of responsible employee to campus safety authority, campus security authority under the Clery Act, and more or less kind of combines the two and says basically if you're a campus security authority, you're a responsible employee. Responsible employees are going to be clearly having the requirement to report cases of sexual violence to the Title IX coordinator. And I think this piece is interesting. Required to provide a written explanation of individual rights and options upon receiving a report. And so I think, one of the things this is going to require for campuses to do is make sure there's some kind of a written form or something that you have that goes out to all of your responsible employees that they can then hand to any student who reports a Title IX violation to them. And I'm not sure that a lot of campuses have thought about it in that way. They've kind of focused on responsible employee getting that student to someone who actually has responsibility for the investigation and things like that, rather than handing them some kind of a document that outlines their rights and options for reporting. So we're going to have to look at creative ways to do that. And it says written explanation. We don't have clarification yet on whether maybe an email explanation, sending a web link would potentially be appropriate or not. And then, of course, we come to training, and I think we'll talk about themes later, but I think if there's a theme in everything we're hearing is making sure that individuals on your campus that have some role in responding to a Title IX issue have training. And so making sure that responsible employees have training to understand what their responsibilities are, and for those who have a responsibility to enact any part of your grievance process, whether it's the person conducting the investigation, to a person maybe hearing a case, to someone who maybe has a role in the appeal process, making sure that they have annual training. And some of the training requirements are that they have training on working with and interviewing persons who are subject to sexual violence. They often use the term trauma-informed interviewing, types of conduct that constitute sexual violence, including making sure we're addressing same-sex sexual violence, consent and the role of drugs and alcohol can play in the ability to give consent, the effects of trauma on memory and different ways that it can affect different individuals, as well as cultural awareness. So I think again, going back to that training piece, and for me, as I sort of think about everything that we've been receiving on this issue in recent months, it almost always comes back to training. And so really putting a lot of time and attention into training, I think, can head off a lot of problems in the long run for institutions. If you make sure that you have, one of the things we've tried to think about on my campus here is that there's different tiers of training. So, your responsible employee faculty member maybe who has no responsibility to supervise a student organization or advising or anything like that might require one level of Title IX training, whereas your faculty member who's an student organization advisor might require another level of training in addition, and so on and so forth. But just making sure you have adequate training for the level of staff and the likelihood that they're going to get a report. Okay, moving on to the next slide. We're going to talk a little bit about this uniform process. And this provision requires that institutions provide a uniform process for disciplinary proceedings for any claims of sexual violence. What they're really referencing here is regarding student-on-student complaints. So they're not really addressing employee issues at this point. They're really focused on student-on-student. I think keep in mind that the context in which this act is coming up is sexual assault. It's rape on college campuses, essentially. So that's the context, and they're primarily focusing on student behavior. Essentially, this provision is designed to stop institutions from allowing institutions to have different processes for athletes or maybe Greek students or other subpopulations of students, in particular where they're being self-managed. I do think there are some challenges with this provision in that I know there are some campuses that actually have very decentralized conduct systems. So, for example, a campus may have it where each college almost has its own disciplinary system and is responsible for handling its own students. So I think that there's going to be some, it's going to be interesting to see how this legislation would play out in that scenario. But I would say the primary reason for this provision actually ties back to athletics. If you had a chance to see the Outside the Lines report from ESPN, a lot of the focus there obviously on student athletes, and a lot of the complaints involve situations involving student athletes. The law is unclear on whether this process of a uniform process would apply to non-sexual violence-based complaints regarding student organizations, because a lot of campuses I know do have a separate process for student organizations. One of the, positives of this provision is that it doesn't prescribe what the process must be. It's just that it has to be uniform within the institution. And so it's also not saying that across all institutions you have to have the same process, which is certainly concerns we had earlier in the earlier versions of this legislation. And then finally, moving on to our final slide on CASA, is guidance and enforcement. Basically, within 180 days of enactment, guidance will be provided on the intersection between Title IX and CASA and resolve any discrepancies. I know that's something we're actually all looking forward to make sure that whether it's the Office of Civil Rights guidance, White House Not Alone report, the Clery Act, CASA, making sure that there is consistency and that those different acts and guidance are all congruent. Also kind of talks about civil penalty. Civil penalties range up to 1% of the institution's annual operating budget, may be imposed for each violation. And then also for failure to complete the survey, civil penalty for noncompliance is up to $150,000 for each violation, including each month the survey is not completed. And then complaints, sort of a statute of limitations for students to file complaints is they must be filed within 180 days after graduation or disaffiliation with the institution. And I think there, we all are kind of aware of situations where a student disaffiliates for a period of time, but then maybe comes back again, especially if you're talking about potentially some community colleges where it's not necessarily a linear progression through a program. And so I'm not really sure how that will end up being played out when we get the final regs, assuming, again, this passes. So with that, I would like to go ahead and turn it over to Laura Bennett, who is going to discuss our next act, the Survivor Outreach and Support Campus Act. Laura?
Thank you, Chris. As Chris mentioned, I'm going to discuss the second act that's on our agenda for today. The Survivor Outreach and Support Campus Act was introduced by both on the Senate and the House side. It has been endorsed by the University of California and a variety of organizations and advocacy groups around the country. It's a little different in that it does not include a specific enforcement edition like the others that we're going to look at. And I did want to let you all know that some of the handouts that you received are the actual text of I believe it's the House version of these bills. We'll send you the Senate versions as well, and another handout that Chris developed that you can use to kind of look at how is your campus already in compliance with CASA, what would be some implications, et cetera. I would also say keep those questions coming. If we don't get to them today, we'll either give you some written response or use the information to develop some additional opportunities through ASCA. So please keep those questions coming. Let me advance the slide a little bit. So the overview of the Survivor Outreach and Support Campus Act, and my feelings on this bill, I think there are a lot of things in here that we're probably already doing, that it kind of formalizes, and then there are some sort of interesting twists that I'm curious to see how they play out. But you can see the major provisions of this act include predominantly establishing what's designated as an independent advocate who will advocate for students who have been victims of sexual assault. There's a requirement to notify the campus of the existence of this person, to define the role, and then this also includes the requirement for victim amnesty that we've already seen. So an overview of the role of the independent advocate. This person is to be appointed not just somebody that you sometimes we joke that people have been gifted the field of student conduct if they have a lot of other responsibilities, and this is not to be one of those positions. This is someone who needs to be both experienced and capable of doing this kind of work. The other interesting factor is that this bill calls for an independent advocate who does not report to anyone who is involved in the chain of investigating or adjudicating sexual violence. And, it's kind of interesting to have someone doing this work who's not in that reporting line. That can also be difficult, especially if you're an institution that has a smaller student affairs division, limited resources. That may prove a little bit difficult. It does look like the founders of this bill took some of that under consideration because the advocate can be someone who is contracted through an MOU, maybe through our local rape crisis center, victims advocacy group. They don't technically have to be an employee of your institution. So I think that's an important factor. It's always nice to see that after the legislation passes, we will get further guidance as to what will regulate the appointment of this person. So that should be coming. And, personally, I think it's interesting that we saw all three of these bills come out at the same time, and there's a lot of overlap. I saw a question earlier about the role of the confidential advisor that was alluded to in CASA, and that's different than what this bill is proposing. The confidential advisor in CASA conducts investigations, does a lot of this work, whereas the person being designated in the SOS bill is an advocate through the campus process. So a very different role. So an important piece of this is notifying the campus that the advocate exists. This probably shouldn't be a challenge. My hope is that we've got folks on our campus who are advocating for students and providing support. So the notification of this would be similar to how you notify the campus of the existence of the Title IX coordinator. Some of the more interesting components relate to the role of the advocate. And this part, I think, is nothing new. I think most campuses have someone employed or accessible to their student body who does this. Obviously, someone who can make sure that a victim or a survivor knows how to report, how to get that immediate emergency medical care, how to get a forensic examination, some crisis counseling, legal services, making sure that the policy is known and that someone can actually get support for going through the process. But I think this slide really gives some of the more, provocative pieces of this legislation. The first point, that this individual must represent the student even when this might conflict with institutional interests. And I think that specific piece of the legislation may cause institutions to look outside, to go through an MOU. I'm curious to see what some of our legal counsel might think about this piece. One thing, and you'll notice a lot of our concerns are written in italics on these slides, just the presence of this point really brings up the idea that our process is adversarial to begin with. And I know ASCA for years has encouraged a non-adversarial, very equally balanced process. So my hope is that we're continuing to move towards that. The second bullet there talks about this person serving as an advocate for a victim through institutional disciplinary meetings. And I think this language is problematic in that it may conflict with what we already have in process about students having an advisor present that they may choose, but they still need to be their own, tell their own story through the conduct process. And so, this is some language that I think we've got to keep an eye on how this develops through the process. Obviously, maintaining confidentiality, that may be a factor in terms of who is appointed to this role. And then a piece of education, that this individual needs to conduct a public information campaign, and that's geared towards the student body. But then they also are responsible for doing some training, some publicity around campus, and that might be geared towards everyone. So again, some more overlapping roles in terms of what we're seeing with regards to support, advocate, that type of role. And then the amnesty policy comes up again as the last component, that this would be a mandatory amnesty policy. And again, I think in spirit, obviously many of us agree with this, that we want to hear about those incidents of sexual violence. We do not want someone who may have been under the influence to not come forward because they're afraid of getting cited for being under 21 and drinking. So very much this is something that many of us already have in place. And it is consistent with what we've already seen from CASA. So with that, that is your SOS summary. And I'm going to turn it over to Sean to speak about our next piece of legislation.
Thanks, Laura. I'm going to talk about our last of our three federal pieces of legislation here, the Hold Accountable and Lend Transparency Act, also known as HALT. Like the other two bills we discussed, it was introduced on July 30th. This one is just in the House, and you can see the list of sponsors there. Actually, there are two sponsors here, co-sponsors, that are also co-sponsors on the House version of the CASA. And another unique twist in this is actually was referred to two committees, the Education Committee, but also the House Judiciary Committee. So it's kind of looking through that civil rights lens as well that the Judiciary Committee will look at. And you'll see as we walk through this bill that it's largely, it's very compliance heavy. There's not a lot on the educational side or training side that we've seen with the other two bills. So just looking at some of the major provisions that we'll talk about, lots of this bill, large parts of this bill discuss what is expected of the Department of Education, and also includes a couple other federal offices or agencies that we haven't really discussed much in our previous, going back to 2011 with OCR, adding a few new federal actors into the pool here, should some of these provisions ever become law. But we talk about new reports that are issued by the government, also a requirement for a survey, different types of fines and what a different definition of fines that you see than in CASA, the creation of a private right of action, which I'll discuss in a little more detail, also looking at just clery fines and policy. So it's a very policy and, I guess I would say, enforcement and compliance-heavy bill. So looking at the disclosure, it's interesting because it's asking for more disclosure of investigations and resolution agreements on the website of the Department of Education. But actually, a lot of the information they ask for in the HALT is you can already find it. When you look at the Not Alone website, the notalone.gov, most of the information they're talking about is already there. I think it's kind of a theme you see with the HALT is that some things are very different from the other bills, and some other provisions seem almost outdated because the things that they're discussing are already part of law. So in terms of enforcement, there's discussion about the levying of fines. Unlike the CASA, though, there really aren't any definitions given. It's undefined the amount that can be fined. So it's, ask the Department of Education that can levy fines against institutions that don't maintain compliance, but doesn't say exactly what the minimum or maximum of that amount of those fines could be. Moving ahead to the private right of action, I found this one pretty odd because what the private right of action piece says is that, okay, if we enact this, it means you can sue for violation of Title IX due to institutional response. But the thing is, that's a already established right. There's actually 2 Supreme Court cases that established the private right of action under Title IX, dating all the way back to 1979. And the fact that we already have institutions that are sued for violation of Title IX proves this point. So it seems kind of an interesting provision when that's something that's been it's been the law for pretty much 35 years. And also it increases clearing penalties, not as high as the CASA does, but one of the kind of errors we caught was that it actually considers the current amount to be lower than what it actually is. It says it's increasing it from $25,000 to $100,000 when actually we're already at about $35,000 for clery violations currently. So it does have a lower cap for the clery violations, and that's not to confuse it with the fines we talked about before that deals with violations of the HALT Act, which would have some sort of undefined fine total that would be determined by the Department of Education. So moving ahead to the climate survey, I'm not going to spend a lot of time on this. There's a lot of similarities here between what's being discussed in the CASA and what's being discussed here. So when these slides go out, you can take a look at the very specific details that they're looking for in terms of instances of violence and indicators of violence and the effectiveness of policies and programs. One of the interesting twists here is that they're looking at this survey as being a cooperation between the Department of Education and the Centers for Disease Control. So CDC has not really been involved in this issue as far as higher education is concerned, but this would involve them in the development of what that survey would look like. And then looking at the HALT, at the policy notification, there are some differences here. All the bills we're talking about discuss the need to make sure that your communities have knowledge of the policies, that people who are involved in reporting or part of the process need to be trained. This discusses some interesting twists that we haven't really seen in other bills, particularly not only that the policy just be posted, but specifically say they must be posted physically. So not just in a website, not just via email, but must be posted physically somewhere on the campus. Additionally, it discusses in more detail the need to distribute it to student organizations, and it gives some examples, including what recognized student organizations, athletic teams, but also asking for the term C being here, plebes, pledges, and new applicants of these groups. So it actually puts a burden on the institution to figure out who those people are and get that information from the applicable student organizations. And we look at issues of athletic recruiting. So if someone becomes a recruit, at what point do we consider them an official recruit? And at what point do we need to send them this information about these policies when they actually haven't even enrolled in the institution yet, but they are a prospective member of an athletic team? Another part that is may cause issues and difficulties for institutions is the need to provide this information not only to recognize student organizations, but to quote here, unaffiliated, unrecognized student groups who, quote, who are known by the institution and act as an unaffiliated student group. So I'm sure most of us can think of somebody on our campus that might be a group that is unofficial or unrecognized. It's much more difficult to figure out who might be members of that group because you don't necessarily have the control to to get that information from the student group, particularly depending on what type of institution you are. So that really adds a lot of work on our end to figure out, who are the members of the unaffiliated group and who are the prospective members of an unaffiliated group. So those are some pretty different provisions here in the HALT that we don't see in some of the other bills. Also looking at government reports, and you'll see here the note of the Inspector General report and the Comptroller General report. The Inspector General they're discussing is the Inspector General's office within the Department of Education. And for those of you that aren't as familiar, the Inspector General's office in each executive department, their job is to do independent audits and investigation of their department to make sure that government funds are being spent appropriately, to make sure that policies and procedures are being kept to appropriately as well. So there'd be a report that would need to be brought to Congress related to the compliance with the Act, directed at the Department of Education. And then secondly, the Comptroller General's report. The Comptroller General is the person who runs the Government Accountability Office. So the GAO's job is really to be an independent auditor of federal spending and any federal programs that use federal money. So this report would not be directed at the Department of Education, but looking at institutional compliance. So the GAO looking at institutions to determine if they are compliant with the Act. Again, that's a different take on some of the things we've seen, and this is the first time in any of the bills we've seen this note of the Comptroller General being involved. And lastly, part of the HALT here is the creation of a sexual assault violence task force, and that is a federal task force that would be a cooperation between the Department of Education and the Department of Justice that would be responsible for reviewing all the things we're discussing, looking at Title IX violations, how does the DOE enforce those? A lot of discussion of looking at the DOE workforce and making sure they are effective. So really looking at it from an enforcement lens. Is the Department of Education doing all that they can to enforce Title IX and enforce any other federal acts that relate to it? So again, going back to that theme with HALT, it's very much a compliance, almost, as we said in the previous slide, check the box look at this issue. There's really no talk of education outside of disseminating your policy, no real talk of training. It's very much focused on the federal government and the apparatus that the federal government uses to enforce Title IX, along with some other interesting pieces for institutions. So that's it for the HALT Act. So I'm going to move it over to Chris, I believe, and he will talk to us about some of the themes that we're seeing.
Thanks, Sean. So just thinking about what does this all mean for us? And one of the things I've been doing over the last several months is really trying to look over everything between all of these three acts, as well as what we've been hearing through the Violence Against Women Act negotiated rulemaking, as well as OCR guidance, and then the White House Task Force report. And I think there's a number of different themes that I think we can pull from all of this. And I've tried to hit some of those here on this slide. One is the expansion of reporting and being more transparent from a campus perspective about how these issues of sexual violence, Title IX issues, are being handled by our campuses. Another one of the themes that I think is present throughout all of this guidance and legislation is that there should be a focus on trauma-informed, culturally relevant trainings. And so just making sure that the individuals who are working with our complainants in particular, and I'll talk about respondents in a minute, understand how trauma impacts victims, and also being aware of kind of cultural issues, gender issues, same-sex issues, that we can really be doing sensitive investigations, interviews, and having sensitive processes. One of the biggest things from my perspective is creating and cultivating a culture of reporting on campus. So I think this is where the provision of the Amnesty Policies come from. This is where the idea of confidential advisors, having someone that a victim or complainant can go to and feel safe in sharing their story with, and they can get the support they need. And really the hope is that they'll eventually decide to report for the university to be able to take some kind of action against the respondent if a violation took place. I kind of already talked about this a little bit, but training is critical. And I think as institutions, one of the constant messages we're getting is that we need to invest resources, whether that's time, whether that's money, to make sure individuals that have key roles in responding to sexual violence and Title IX issues are well trained. And then another theme is the increased coordination between campus and local law enforcement and resources, whether that's your local domestic violence clinic, rape crisis center, et cetera, but making sure that there's more coordination and communication between all of those entities. Some additional themes that I think we have seen is you need to be conducting climate surveys. And I think, again, the rationale for this is based on the belief of underreporting of rapes, both on campus and certainly within society. The idea is that the best way you can get a sense as to what your climate as it relates to sexual violence is by conducting climate surveys. We've heard that from the White House Task Force report. I think we've heard that loud and clear through these pieces of legislation as well. Addressing campus climate surveys, there were some questions regarding do we need to do this now, especially as April 15th is a date that's been identified as a date they need to be done by. The reality is that none of these are laws yet. They haven't passed. They're proposed legislation at this point. But you can't read these laws or these proposed pieces of legislation in isolation to what we've heard from the White House in the Not Alone report, in which they suggested that institutions voluntarily conduct campus climate surveys sometime this academic year, ideally spring of this academic year, so that would be spring 2015, and that there would likely be some requirement that there be campus climate surveys moving forward. I know there's also a question about some campuses are conducting their own. This legislation has this Secretary of the Department of Education creating a survey. The Not Alone report referenced Rutgers University piloting a survey. We had a discussion here on my campus about whether or not we're going to conduct our own survey or whether we wanted to utilize a survey that's already out there. I think those are conversations certainly worth having. My perspective is it would not be a bad idea to voluntarily conduct a climate survey on your campus sometime during this academic year. Regardless of what happens with this piece of legislation. Another theme is providing and informing students and complainants and victims of the opportunities for access to confidential advocates. Again, the belief being that if there's someone that can keep the information confidential, that a victim or complainant is more likely to report that information, and at least if we have the information as a campus, we have a better idea of what the issues are and can address them. Increasing transparent communication between cases and processes, making sure our students understand what they can expect if they file a complaint, and making sure they also understand what the resources are. Not only increased transparency for institutions, but increased accountability for institutions and for the government. I think some of this legislation is really about making sure that OCR is being held accountable, that they're actually enforcing the laws on institutions when they become aware of a violation. I think there's a lot more detail and a lot more focus on how we do our work in student conduct. And that's just something, again, that seems to be a theme running throughout. And then finally, increased enforcement options. I think there are a lot of questions regarding respondents and why respondents aren't represented in the legislation anywhere. And I think a couple of thoughts I have to that, and I think one of those is the idea that there's a belief that oftentimes the deck is already stacked against a victim, especially if a process that a campus is using to resolve a Title IX issue is one that is modeled after the criminal justice system, then that's a process that they believe is slanted. Having said that, I think that we as an association, as a profession, have long held that a campus conduct process ought to be equitable to all parties involved. So when we're providing a right or a resource to one party, the best campuses, the best responses provide a similar or the same kind of a resource to the other party. A lot of processes historically have allowed, for example, for respondents or accused students to have an advisor present. They haven't necessarily allowed for a victim to have an advisor or an advocate present. A lot of campuses historically have allowed for accused students to appeal an outcome of a conduct case. A lot of campuses, until recently, hadn't been offering that same right to victims or complainants. So the perspective that this legislation is coming from is about trying to even the playing field. At the end of the day, I think we believe as an association that it needs to be balanced for both parties. So just because we're providing now in this legislation potentially for a student victim to be able to have a confidential advisor, we ought to be looking on our campus to find out, well, what resources are we providing essentially to respondents as well. And so I think, I don't know if that addresses all of the respondent questions, but understanding the perspective that this is coming from, why are the legislators focused on victims' rights or complainants' rights? I think part of that is that's who a lot of them have been hearing from. And when they look at policies and responses historically over time, what they see is processes where campuses maybe weren't providing some similar rights to complainants. And now we need to make sure we don't have the pendulum swing the other way. And so the idea is to be in the middle where we're providing similar rights to both parties. And with that, I'd like to go ahead and turn things over to Sean, who's going to talk a little bit about the legislative process and where these bills are at.
Thanks, Chris. So in talking about where these bills are currently and where they're likely to go, we have our flow chart here that I have to give credit to Brian Glick for putting together for us. Although there is that temptation just to put the Schoolhouse Rock video on there that we all learned how a bill becomes law, but that process remains the same. So we talk about all the bills have been introduced and read into the record. Right now we're at a point where all the bills have been referred to their respective committees. Usually the committee within each house that deals with education issues. Although the HALT bill, like I said before, is also with the House Judiciary Committee. So we're really at the beginning of that step right now where you see a step 2, and that involves usually hearings that take place, and then following however many hearings that are held on a particular bill or issue, then votes from that committee. Right now I know the HELP committee in the Senate, so HELP being an acronym for Health, Education, Labor, and Pensions Committee, which is where our education issues are heard in the Senate. They did have some hearings during the summer related to college sexual assault, and this is really before most of these bills were introduced or were defined. So it is likely moving forward, regardless of how the bill progresses legislatively, that there will be hearings during the course of the remainder of this Congress. But after a hearing, if a bill gets passed through the committee, it's referred to the full chamber, which again, this is greatly simplifying the process, as there are all the amendment processes and other rules within each house. But generally, once it's referred to the full chamber, it's held for a vote, and if it does pass the one house, then obviously that we go through that same process again with the other house. And if both houses pass the bill, it's referred to what's called a conference committee, and where if there's any differences between the House and Senate version, those are ironed out during the conference committee. And if it goes through there, it will go to the president's desk for his signature or veto. So Right now, though, we are early in step 2 in the process of all these bills that we've discussed in the federal level. So it's important to keep that in mind as we move forward, because we're talking about the provisions here and what the possible impacts are, but these aren't happening tomorrow. So it's good to have a sense in the pre-plan, but a lot can happen between now and when these bills may become law, and many of these provisions may not ever enter law. We don't know. But looking at where things may go, there are hearings that will likely to happen as we move forward. What really makes things unclear is that fact that we're in an election season, and with the midterm elections coming up, it's unclear what action may be taken before the elections happen, and then whatever the results of those elections are, depending on particularly which party still has control of the Senate, may impact what the decisions are particularly within the Senate, but in either house between the election and the time that the new Congress is sworn in early next year. So some of these things are real unknowns, and we're not sure where they'll end up until we're done with early November in the elections. GovTrack, which is a website that tracks legislation, and I recommend everyone check it out. It rates all 3 bills as unlikely to pass in their current form in the current Congress. But I think what we're really seeing and also hearing from several colleagues, and I know a number of our members have had opportunities to meet and talk with legislators, particularly in the Senate, but also in the House, see that some of these provisions, if the CASA bill as it stands or any of the other bills as they stand, don't move forward on their own, a number of these provisions may get roped into and added into the reauthorization of the Higher Education Act, which will likely take place in the next Congress. So even if the bill itself does not go anywhere, the provisions and the ideas that are in them very easily may live on and be added into other legislation. So don't just look at the bill itself and its chances, but let's look at where do we think these ideas may fit in, because that's something we've seen a lot in the past number of years with different pieces of legislation that are proposed and then added, whether it be changes to Clery or changes to FERPA, things along those lines. They've been added in as part of the Higher Education Act. Also, I do want to discuss a little bit what's going on in our states, and that's it's been a really active summer when it comes to state action on this issue, and obviously a lot of conversations within the association on that, and with Matt and Chris and Laura. But you've heard recently a lot of press about the bill that was passed recently in California, the affirmative consent bill, which is often being called the Yes Means Yes bill. It is the first state in the country that they've passed an affirmative consent requirement for all its colleges and universities. So it is groundbreaking. I think it's important to realize what the bill says and what it doesn't. It doesn't state that consent must be verbal. It does give leeway for consent to be via body language or body motions. So it is not a completely verbal consent bill, but it is affirmative. And also, if you look at the definition, if you can compare it to the definitions at a lot of campuses, particularly new consent definitions that may have been developed in the past couple of years, I think you'll find that it's very similar to what many colleges and universities are developing on their own campuses. Additionally, in California, just as an aside as well, they also have legislated and put into statute the requirement that sexual misconduct hearings be heard, or anything under sexual misconduct, partner violence, and stalking be heard on the preponderance standard. So we're not really talking about that much in this presentation, preponderance standard, but it has not been legislated federally. It's been issued as guidance from OCR, but it has not been put into statute. There was talked about putting it into VAWA, but it ended up getting cut out of this bill and was not included. So we're seeing that in California, and actually to jump ahead to Connecticut. Connecticut is actually, their bill is in place. It was passed and signed in May, and the Connecticut law is very comprehensive, and I speak as a person at a Connecticut institution, so it's had a lot of time to review it, and a lot of the pieces that are actually in the Connecticut bill are reflected in is reflected in what you see in some of the federal bills, particularly the increased reporting, the discussion of more training and more dissemination of information. Also, Connecticut, we became the first state to require a preponderance standard for these matters for colleges and universities in the state. The MOU provision you see there actually is not with law enforcement. Connecticut is requiring MOUs with local sexual assaults and domestic violence crisis centers. So that's something that Connecticut colleges and universities will be mandated to have by the end of this year. New York also has a pending bill, also more on the law enforcement side, requiring law enforcement notification for quote-unquote violent felonies, except where limited by federal law. So the New York bill does give an exception in terms of the sexual assaults and allowing victims to make the choice, but there's a lot of discussion around this bill with the legislation in New York wanting more law enforcement involvement when it comes to sexual assault on college campuses. New Jersey as well, actually there needs to be a correction there with the New Jersey bill. The bill proposes a $50,000 fine for institutions who, what they call, fail to appropriately respond to a sexual assault incident on their campus. It's unclear what they mean by failing to appropriately respond. I guess that would have to be decided by the state government there and their own Department of Education. But there are also some more New Jersey provisions that are out there. I didn't get a chance to add to the slide, but they have a bill also proposing to add what they call a confidential advocate, which is probably more aligned with Laura's description of the SOS bill at the federal level as opposed to the CASA bill, more on the advocacy role and less on the advisor side. Also, they're asking for increased reporting in a new bill. And then a last bill that they've proposed makes mandatory notification of law enforcement if an alleged victim on campus if they were allegedly assaulted by a faculty or staff member. So, and keep in mind, this has nothing to do with the victim being a minor. So if they're a student, regardless of age, if the accused person is a faculty or staff member, the institution would have to report that to local law enforcement, and that's drawing some concern from victim advocates because it's taking away that choice of whether to go to law enforcement away from the victim. That's what's kind of going on in some states. But I will say, if there's lots of questions out here and people are asking about various topics and issues, and if you know something that's happening in your state as well, please let us know. I've received notification from various folks in different states that have otherwise we may not have seen it, or I wouldn't have seen it as soon. I know some of our colleagues in California early on when the California bill was proposed sent me a note, and so I was able to kind of track it and see what was happening. So please let us know what's going on out there. And if you are interested in this topic, please contact me or contact the ASCA Central Office, and they'll get you in touch. We do have a legislative and legal issues committee and community of practice, and we're looking for folks who are interested in this topic and want to have further discussions and see what the ASCA can do to further advocate for our members on these areas. So with that, I will pass it along.
Thanks, Sean. Oops. Sorry about that. I skipped a slide here. So what we're going to do is just talk a little bit at this point about what are we doing as an association. Also, how can you help and get involved in advocacy efforts? We've had the opportunity over the last couple of months to speak with several Senator staff members. And based on those conversations and what some of the initial provisions of this legislation might have looked like, it does appear that we've been effective in having an impact on the language and some of the provisions of these bills. Some of the things that I know from having a chance to speak with staff members with Senator Marco Rubio, prior versions of the bill included language that would have required campuses report all sexual assaults to law enforcement as a mandatory report. There was also a provision that was under discussion for making campuses responsible for all sexual assaults within a 25-mile radius of campus. And then there were some other more regulatory requirements in terms of reporting and things like that, as well as some discussion of a one-size-fits-all approach, kind of a here's how you need to respond, and it didn't matter what kind of institution you were. So we don't see those provisions in in any of the three bills we've spent time, the federal bills we've spent time discussing today, and I think that's because of advocacy efforts on our part, on the part of other higher ed associations as well. We're going to continue to advocate for policies that are practical and that will help address the important issue and make sure for a prompt and fair and equitable process for all of our students that are involved. Over the last, really, it's just been the last couple of months, we've had the opportunity to meet with a number of individuals involved in these issues on a national scale. And I'd be remiss if we didn't spend a little time just thanking Brett Socolow and three past ASCA presidents, Sonny Schuster, Scott Lewis, and Daniel Swinton, for really helping get ASCA to the table by connecting us with the White House staff that was working on the Not Alone report. And since then, it seems like we are spending time talking with a lot of state legislators or national legislators. We've had a chance to speak with staff in Vice President Biden's office. I've already mentioned Marco Rubio, Senator Kristen Gillibrand, Claire McCaskill, Dick Durbin, Charles Schumer, Mark Warner, Richard Blumenthal, Tim Bishop. We've met with several state legislators in a number of different states. I also want to thank Dave Bergen, Brent Erickson, and Sean Gallagher for spending some time in meetings with different staffs of senators, both state and federal. And so really through these efforts, we're going to continue these conversations with these staff members. I can speak to speaking with Rubio's staff, definitely seem open to feedback and suggestions. I think there are certainly different senators have different motivations for why they're involved in this, but there does seem to be some interest in trying to create legislation that will make sense and help address the issue. So with that, I'm going to turn it over to Laura to talk about some more advocacy efforts and ways to get involved.
Thank you, Chris. I saw a question come up after I was talking earlier in the presentation about, why isn't ASCA doing more than just keeping an eye on some things? And believe me, I can assure you, we're doing more than just watching about what's happening. We certainly know we can't control what the government does. We can't control a lot of things, but we very much have some influence. And I know, Chris already shared some of how we can tell that we've had an effect through our efforts. We're certainly getting our word out there on all fronts and trying to really speak for the profession and for the realities that we face on a day-to-day basis. You may have seen some of the things we published recently. We're trying to give you all tools to be able to have conversations on your campus about what the most equitable processes look like, how to make some of this happen, and trying to make it work for all of our institutional types. Hopefully you've read the law and policy Matt and I co-authored, I think it was back in May, where we really talked about the difference and why our conduct process is not a criminal process and what our students look to get from it and learn from it. The gold standard report, where we try to be pretty comprehensive in terms of these are some of the underlying things that should be in place when you're dealing with these kinds of cases. Obviously, the nuances and the details are going to look different for your campus culture. Then we've moved to really pushing some things out externally, trying to hit some of the stakeholders that might be on our campus, whether it's college presidents, partners in student affairs, campus attorneys. So we are very much trying to help spread the word about the way we think conduct does work best, rooted in a lot of our best practices. And we've partnered a lot with the Association for Public and Land Grant Universities as they're trying to figure out some of these pieces. They've actually come to us and said, hey, let's get together, help us. How are you doing some of this work? Where are our messages overlapping? So hopefully some of you have seen some value in some of those publications. Also, I want to speak to some of the other conversations that we've been having behind the scenes. You may read about some of these in Matt Gregory's presidential updates, but want to give you a heads up. Earlier this month, Matt and I spent some time with the Office for Civil Rights Sexual Harassment Network, which they had representation from all of their offices around the country, and we taught them about how conduct works and what are some best practices and what is it like to investigate cases. So I think that was some time very well spent. We have some ongoing conversations with the technical assistance branch of the Violence Against Women program as well as the national office, and are looking at some ways that we can partner really around developing some standard trainings, things that we can offer not only to some of the schools that have grants, but really make available to other institutions through ASCA. We're working with IACLEA. I think this one's actually on there twice. Predominantly, the most current activity is a task force where we're looking at best practices between student conduct and campus or local law enforcement when it comes to resolving cases of sexual violence. What do those MOUs look like? How do you partner? And we're trying to provide some resources for you all as examples across the institutional types. We also have entered into an MOU as part of a grant application geared towards looking at sex offenders and how to provide some appropriate, reacclimation and revisioning back into the community. We've got a lot going on. So we are looking to continually put ourselves at the table and really go forward once we are there. And I would encourage you all to get involved. Our board of directors is fairly small, and we're able to be the voice, but we need to hear from you. Having worked at a public, private, and now a community college, the worlds are very different, and how we do this work, in order for us to meet your needs, we really need to encourage you to bring to the table what your concerns are. So I think Matt's going to talk a little about what you can do, and then we will try to tackle some questions, and whatever we don't get to, we'll be able to roll out later. If you don't have the PowerPoint, you will get another link to it, but I think it was sent out earlier today. I saw that question come up on our chat.
Yeah, thank you, Laura. And this last slide, I don't have to spend a lot of time on it because it does reiterate some things we've already said. And you keep hearing us mention names of ASCA members. And on this slide, we talk about some work that we're doing with IACLEA. We had a lot of questions on MOU with law enforcement. That task force will be having some of those conversations about what does a good MOU look like and what would be the definition of a clear MOU in terms of information sharing. And Jeffrey Stefanchik and Donna Hyder, the two co-chairs of that task force on behalf of ASCA. So we will have some more things coming out. And to reiterate, if you have or hear concerns, please communicate your concerns to the Legislative Issues Committee or to an ASCA board member. The reality is we have several members engaged on this front. If you've heard several names today, I want to take a moment and recognize another person. That's Kat Riley. Kat has been involved in the national level, and she is regularly engaging us in conversation with ASCA and trying to make sure that we are aware of information that she may be privy to. And as an association, we need that information to be able to stay and remain in the dialogue and be able to keep our influence and ability to continue to affect some of these bills that are being proposed. And the reality is some of the questions also asked about this passing, and Sean mentioned that, even if it doesn't pass this session, the 113th session, they very well might be reintroduced in the 114th session. So we need to continue to stay on top of it, continue to have conversations with persons at the national level. The reality is we know something's coming. We don't know when that will come, but we know something's coming. So we need to continue to advocate for ourselves and what is best for our profession. And to Laura's point, we hope you get involved with that. And now I think we have a few minutes we'd like to take some time and answer some questions and comments in the Q&A. So I'll start. I know there were some questions, as I mentioned, about the MOU. Largely for the MOU in terms of what it might be looking for, it's the information sharing back and forth between the campus and the law enforcement agency or public safety office or security. That might include not only the actual content of information that might be in the body of a report, but it could also be cooperative training or collaborative training that might need to take place between the agencies or for the staff who might be involved. the investigations, how that might look like, who's going to be doing that from both parties, both sides, law enforcement and campus, and then arguably any evidence preservation and how evidence might be shared. I'm going to quickly talk about the waiver. The key thing I can say about the waiver in terms of a campus who cannot enter into an agreement with a law enforcement agency, whether it's rejected or it's not possible, there's an opportunity to keep a paper trail of all that. We still might want to draft an MOU, what we think it might look like, offer it to them with a cover letter that requests their consideration and response, and then ultimately wherever that response is, and I would make all effort to get it in writing, you can then submit that paper trail to the Secretary of Ed and Department of Education, and a waiver may be granted for you. So I hope that answers the question on waiver. With that, I'm going to pass it along to some of my colleagues who might be able to answer some of the other questions.
I'll jump in. There's a question about the uniform process, and a couple questions related to how this impacts undergraduate students as opposed to professional schools. And as many of us who may work on campuses that have really semi-autonomous law, medical, veterinary, dental schools, it's often that those schools handle their own student conduct issues as opposed to what may be going on in the undergraduate side. It seems from the text of the bill that it states, and the student, regardless of student status, it actually lists academic status as a condition that would not impact the uniformity of the process. So regardless of a student's academic status, they need to go through the same uniform process. So as the bill stands, at least from my read of it, it would seem that law students, medical students, other professional students would have to go through the same type of process. Now that may change moving forward, or if it does stay that way, that would really mean the need to outreach possibly to graduate schools and professional schools that maybe you and your work don't have a lot of interaction with, and getting them in the fold for your process. So that's something to watch as it moves forward, because as it reads now, I don't really see a reading that doesn't end up in that result.
This is Laura. I'm just going to jump in because we're running short on time, and I've seen a couple questions around this. We did record the webinar, and so you'll receive a link to be able to access the recording and share it with folks who maybe weren't able to join you today. You'll also receive the handouts again, or links to the handouts. And one of those is a tool that Crystal Shivo developed where it's really looking at some of the pieces of CASA specifically and being able to tell, what are you already doing, what might need to change. It'll be a good model that you can use, whether it's CASA or another piece of legislation. And I would encourage you to read the text of the bills. We tried to give you an overview, but I know there have been some real nuanced questions around this word versus that word. And I'm definitely a context person that helps to actually read it and get a sense of what it might mean for your institution. So with that, our time might be coming to an end. Matt, do you want to wrap us up?
Sure, absolutely. I want to thank everybody for your time today and for your interest and for your support of ASCA. We very much value your engagement, and like we've said several times, it's not just the three of us who are have the privilege of serving as association presidents, and it's not just Sean and Brian Glick who have been leading our legislative issues committee in the past, and Brian in his former role as chair. It's all of us. It's the whole association. So please continue to stay engaged and reach out to a board member, reach out to Sean or Brian or myself or Laura and Chris, and it takes all of us. So we will continue to keep our eye on the game and do what we can to be able to produce good benefits and resources for our members. That has been a priority this year, and we will continue that. With that, Sarah, I don't know if you want to talk about the recording and availability after today's webinar.
Sure. Thanks, Matt. The recording will be sent out to all of those who are registered, and you can feel free to share that with others. And that will include both the PowerPoint slides and the reference materials that Laura mentioned. We also encourage, if you are not yet a member of ASCA, to please join us in membership. You can find information about the organization and joining on our website at www.theasca.org. And we thank you for joining us today, and have a great rest of your afternoon.